Nature has bestowed on women the exclusive ability to reproduce life. Motherhood is a one of a kind phenomenal experience. However, not all women are able to have biological children of their own. Yet, their yearning to nurture children remains strong. Hello, viewers. Subhadra and I welcome you to another interesting episode of Tête-à-Tête, wherein we discuss surrogacy and the laws around it.
Let us deal with what are the basics of surrogacy. Now, surrogacy is a method of any assisted reproduction. A woman agrees to become pregnant and she carries the child in a womb to give birth and hand over the child to another person or a couple who cannot have children of their own. So there are two types of surrogacies. One is the traditional surrogacy and the other is the gestational surrogacy. Now, in the traditional surrogacy, the woman is carrying the child in the womb and is also the biological mother as she is the egg donor. Such woman conceives using the biological father's sperm. So the woman also carries the child and has a genetic link to that child. So such child will be handed over to the biological father and his wife. So typically this approach is followed when either of the couple have trouble conceiving naturally
Right.
or for their family members or friends. Now coming into the second type, which is the gestational surrogacy, the woman here is carrying the child in her womb and has no genetic or any biological connect with the child as such. And such woman conceives using the egg and the sperm, which is implanted through the assisted reproductive technology, which is today called as the A.R.T methods, which is like IVF or IUI, etc. So literally here the woman only rents the womb and once she delivers, the child is handed over to the couple. So typically this approach is followed in couples who are unable to conceive naturally or have a history of medical conditions, infertility, etc.
We'll now look at the different types of arrangements of surrogacy. Typically, the arrangements are two types: altruistic surrogacy and commercial surrogacy. Fundamentally, the process of renting the womb is the same, but in altruistic pregnancy, the arrangement is such that only the medical expenses and pregnancy related expenses, nutritional expenses of the woman who's renting the womb is taken care of. Now, typically, there's no consideration involved. It is done more on a human consideration. So typically these arrangements are between family members or friends. Exactly opposite is the commercial surrogacy, wherein it is a properly drafted contract where the mother who agrees to literally rent the womb. In addition, in addition to the pregnancy related expenses, nutritional expenses, there is a lump sum consideration that is paid.
Now, coming to the laws in India pertaining to surrogacy, if you see, the surrogacy was legalized in 2002, and later the commercial surrogacy was also banned in 2015. So, the Surrogacy Regulation Act 2021 was passed on 25th December 2021, and it also came into force on 25th January 2022. And this long pending bill eventually it became an act.
While we're running through the Act, we'll start with the basics of who can avail surrogacy services under the Surrogacy Regulation Act of 2021. Subhadra.
See, surrogacy is generally, it can be availed by either the intending couple or the intending woman. And the Act clearly defines an intending couple as the couple who intends to become parents through surrogacy. And there is a medical indication necessitating gestational surrogacy and who intend to become parents through surrogacy. So the intending couple are married and they are between the age of 23 to 50 years in the case of female and between 26 to 55 years in case of male on the day of certification.
The Act also defines an intending woman. The definition of an intending woman is either a widow or a divorcee who is between 35 and 45 years of age and who intends to avail surrogacy services. We saw in the Act that who can avail surrogacy services, but the Act also clearly lays down who can be a surrogate.
Now, only a married woman who's having a child of her own and is between the age of 25 to 35 years of age on the day of implantation can be a surrogate mother or help in surrogacy, either by donating her egg or oocyte. She should be a willing woman. Willing meaning here willing to go through the entire surrogacy process.
Correct.
And no woman shall act as a surrogate more than once in a lifetime. Such woman who is willing to act as a surrogate must also procure a certificate of fitness from a registered medical practitioner.
Subhadra, it's very relevant that you just mentioned that any woman can be a surrogate for not more than once in her lifetime. The intention is to ban commercial surrogacy. India being a poor country, there is extreme rampant poverty. At the same time, there's availability of technology that makes it the perfect destination for surrogacy, but over exploitation as well. So it's with that intention that the Act altogether bans a commercial surrogacy. It recognizes only altruistic surrogacy. Despite the ban, if commercial surrogacy is being practiced, then it is an offense which is punishable with penalties of up to 10 lakhs and above.
So here the Act allows for gestational surrogacy only. Therefore, any woman who's going to use her biological eggs is prohibited from being a surrogate. So this way, only the intending couple or the intending woman, they become the biological parent or parents. Right. So the child born through the surrogacy shall have the same rights provided to any natural child under the law.
Only surrogacy clinics which are registered under this Act can carry on and provide surrogacy services. So all employees working therein have to be qualified and registered under this Act. It naturally goes without saying that all gynecologists, pediatricians, embryologists, and related support service staff have to be experienced as well as qualified, and care should be taken to see surrogacy services are provided only in such surrogacy clinics which are registered under this Act. Also, another point to be noted is no surrogacy clinic can advertise or promote or canvass their services for commercial surrogacy purposes or in any way induce any surrogates. So, Badra, like with any Act, this Act also has quite a few gray areas that need to be addressed first and then plugged in eventually. While the Act itself has been lauded as a very progressive step into the future, there have been a couple of views on the same. For instance, by banning commercial surrogacy altogether, the intention of the Act was basically to ensure prevention of illegal surrogacy market. And India has a thriving illegal surrogacy market. The intention purely being to prevent poor uneducated women from being exploited. However, completely banning commercial surrogacy, some experts view may prove counterproductive for those who are genuinely interested in having children through alternative means.
So there is in general view that by restricting the eligibility of surrogacy only to a married couple, which is the man and the woman, and a single woman, especially either a widow or a divorced woman, the larger section has been excluded. Like, for example, the same gender couples who cannot biologically give birth, single men, single women who do not want to marry but yet would love to enjoy their motherhood legitimately. With the courts also recognizing the LGBTQ community, I think this is a very glaring dichotomy.
We have seen the act and the legal aspects of the act, but we also need to have a look at the ethical and moral aspects of surrogacy, because it's about bringing a baby into this world. But naturally, the ethical and moral aspects will come into the being. In fact, I believe the legal aspects stem from the ethical and moral, and they have to address it as well. Several issues and questions arise. Some of the most important and the most natural question is the nationality of the child. What would be the nationality of the child born to an Indian surrogate mother whose parents are foreign nationals?
So, regarding the question on nationality, as per the Indian constitution, when a child is born in India from an Indian surrogate mother, it shall be deemed to be actually the Indian citizen. This is the norm if the surrogacy is a traditional one. That is, if the woman is carrying the child in her womb and is also the biological mother, as she is the egg donor.
There is a gray area in case of gestational surrogacy. Now, gestational surrogacy is when the woman is only literally renting her womb. She is not the biological mother, she is not the egg donor. She is carrying it on behalf of another couple. The nationality is a challenge in such cases. Typically, the Supreme Court has actually considered the possibility of granting a dual citizenship to such children. In fact, it has actually also asked the government to consider and mull over the possibility of granting a dual citizenship. Obviously, the rights in our country will be limited. Nevertheless, the possibility of a dual citizenship is being considered by the government.
So, relating to what you spoke about the nationality, the Supreme Court here has very clearly brought out a landmark case, which is called as the Baby Manji Yamada case, which was in 2008. To state some of the brief facts is Baby Manji was actually born through gestational surrogacy, and she was born for a Japanese couple where the biological parents and the Indian woman agreed to rent the womb and birth the baby. So this baby girl was born in July 2008. However, little before the birth, the couple separated, and then the Japanese mother refused to accept the child. So the surrogate, being the gestational surrogate, she also did not want to accept the child either. So the child continued to remain in India under the eye of her paternal grandmother who came to India. Now, the biological father was very keen on taking Manji back to Japan. However, the Japanese government didn't recognize such kind of surrogacy, and hence they did not even confer the nationality or nor gave a passport. So in India, even the birth certificate could not be issued because of the ambiguity of the mother, whether it is a Japanese or it's going to be an Indian mother. Finally, to put all this through, the Supreme Court intervened and directed the government to issue a travel certificate to the baby Manji. And the Japanese government also issued a 1 year travel visa on humanitarian grounds. Eventually, baby Manji went back to Japan to her biological father. The only way she could have become a Japanese national is for her father to establish the paternity or adopt her family. This case law highlighted the glaring lack of surrogacy laws and the gray areas surrounding here.
While on the issue of nationality, we take a look at another landmark case also that happened in 2008. Jan Balas versus Anand Municipality. A look at the facts in brief. Jan Balas and his wife Suzanne were a German couple. Now, Suzanne could not conceive naturally, and so the couple chose to travel to India to have a surrogate child. Through IVF process, a gestational surrogate mother gave birth to twin baby boys. Um, Now, here's where the challenge comes. The birth certificate had the name of the German father and the surrogate mother. However, the passport contained the name of the German couple, Jan Balaz and Suzanne. Now, Germany did not recognize children born through surrogacy. So, therefore, Germany refused to grant it the German nationality status. Being surrogate children born in India, India did not give its Indian nationality to these children. Now, the tragic part is, as a result of being nationality less, these twin boys grew up for 2 years in a foster home in India. The legal case kept going on through these 2 years. Eventually, Germany agreed to grant the children German nationality provided the couple adopted them. And India did its bit by facilitating travel permits and exit, like in the previous case. So basically, it was a case of having surrogate children and adopting them to actually take them back into their country. Another burning issue is, can a woman who opts for birthing a child through surrogacy avail maternity leave and benefits at her workplace?
Yes, this is a very important question. I think this issue was clearly dealt in 2013 in a case called as Kalai Selvi versus Chennai Port Trust. So in this case, Kalai Selvi was an employee of the Chennai Port Trust, and she chose to have a baby through the surrogacy after she lost her only son. So after the delivery of the baby, she applied for the maternity leave and the other benefits. However, she was denied all the maternity benefits because they did not recognize the act of surrogacy, you know. Though laws allowed her for availing benefits for children through adoption, but surrogacy was not recognized at that point of time.
Okay.
So there was no law in place to address such issues. So the courts relied on the Universal Declaration of Human Rights and the International Convention of Child Rights, and then held that such benefits have to definitely be made available to mothers who have children through surrogacy as well.
Subhadra, there are other issues which still need some clarity, either in the act or by the courts and law in itself. There have been several instances where babies born through surrogacy have been abandoned or left behind, either due to the gender of the baby or because they are born with some medical or health deficiencies. In fact, I'd like to bring to your notice that in 2012, a twin birth, a boy and a girl, were born to a surrogate mother, agreed to by an Australian couple. However, the baby boy, Gamma, in fact, the case is known as the baby Gamma case, the baby boy was diagnosed with Down syndrome. And the Australian couple abandoned the baby boy and chose to only take the baby girl and go back to Australia. Now, there have been other instances where there have, due to the gender of the baby, they have left behind. Now, what is the status of the baby in such case? Because neither the surrogate has the, invariably in countries like India, the surrogate mother doesn't have the wherewithal to raise a child. So they wouldn't
Right.
accept the baby either. And the parents who commissioned the surrogacy don't want to take the baby either. So the baby is left in lurch. Besides that, there is also the fear of such babies being taken for trafficking or sold off or sexually abused. These are other issues
Right.
we need to look into.
Definitely. So, such issues arise only due to the lack of clear legislations, not only in India but also in other countries as well. So, countries such as Thailand, where the baby gamma case happened swiftly, acted by all together banning commercial surrogacy in their country. So, such issues arise only due to the lack of clear legislations, not only in India but also in other countries as well. So countries like Thailand, where this baby gamma case has happened, they have swiftly acted together and they have banned commercial surrogacy in their country. So it's extremely important that our country as well takes into consideration these gray areas and immediately acts upon this and gives a clarity in the Surrogacy Act which will help people to promote the noble act of surrogacy in a positive aspect.
Yes. India is a favorite destination for surrogacy. It has infamously earned a reputation of having a rent-a-womb industry. It is also known as the outsourced pregnancy capital or a procreative capital. Illegal and unchecked fertility tourism or reproductive tourism has been thriving in our country for years now. There are many reasons to it. Obviously, poverty, coupled with an advanced reproductive technology at relatively lower costs as compared to foreign nations, and lack of effective surrogacy laws have made commercial surrogacy rampant in India, which is probably why the act has altogether banned commercial surrogacy.
So, the Surrogacy Regulation Act 2021 and the Assisted Reproductive Technology Regulation Act 2021 have been enacted in order to strike a balance between encouraging the surrogacy while regulating and banning commercial surrogacy to prevent exploitation of women in a larger aspect. The response to the laws has been mixed, with some glaring loopholes left to be addressed.
Only effective implementation of laws can ensure that childbirth through surrogacy continues to remain a special feeling. We hope you enjoyed this edition of our Tête-à-Tête. Thank you for joining.